Welcome to the IR Digital Podcast, a part of IR Global, the largest international professional services network. I'm your host of the IR Digital Podcast, Jennifer Riggins. Today, we are sitting down again with Michael Einbinder, founding partner of New York City-based business law firm Einbinder Dunn, LLP, with extensive experience both in representing clients and acting as an arbitrator. Definitely check out our first interview in the same feed, where we talked about the importance of documentation as a contingency plan for your whole business. And as always, if you like this, please like it, give it a good review, share it with people that you think would benefit from it. Today, we're getting into all things franchise law, from the tiny little franchise organization to the giant one, to franchisees and the differences and where everyone fits on that spectrum. So thank you all so much for listening, and thank you, Michael, for coming. For those that didn't listen to the first one yet, why don't you take a moment to introduce yourself, please?
Good morning, Jennifer. My name is Michael Einbinder. I'm a partner, as you said, in Einbinder Dunn. We're based in New York City, but have a nationwide practice. We represent business clients. Almost our entire practice is representing business clients, with few exceptions. A substantial part of our practice is dispute resolution, corporate transactions, business transactions of all kinds. And a large part of our practice, where we do all of the work that I just described, is in representing franchise clients. We represent both franchisors and franchisees.
Okay.
All sorts of matters for them.
Okay, and who would benefit from listening to this podcast? Anybody that's interested in getting a franchise, anyone that works in franchises, more than that?
Well, in other professionals who might listen to this, other people who are advisors, lawyers, accountants, etc., could listen to this if they have clients who are seeking to grow either their business portfolio or their existing business through franchising. I can talk about how one franchises a business or how one acquires a franchise. We do both. And there's a lot of information to obtain from that.
And this may be counterintuitive to the idea of franchises, but I guess there are also investors for franchises, right?
Right. I mean, we think of the people who buy franchises as investors in those businesses, and they are entitled to obtain information from the franchisor as an investor would, say, for example, as an investor would from a stock portfolio, from a stock prospectus. Same kind of information is provided to franchisees when they buy franchises.
And I think for most of us, lay people, at least, we look at franchise as something we associate with restaurants or restaurant chains, things like that. So is that what we're mainly talking about, restaurants, or what are you identifying in the world of franchise? What is your purvey of clients?
Well, restaurants represent a significant portion of the world of franchising. Everyone's familiar with McDonald's, Burger King's, international concepts all over the place. In the U.S., Dunkin' Donuts is a large franchisor. Subway is a large franchisor. Certainly, food-related businesses and markets like 7-Eleven, for example, are franchise businesses. But franchising really is involved in many, many different aspects of business. For example, there are a number of franchises. There are many, many franchisors who are involved in the home services space. Gardeners, grout mechanics, some of them are called, grout businesses, flooring businesses, painting, lighting, anything that involves what you need as a homeowner. Those businesses are often franchised. There are businesses that are franchised that are childcare centers. Many, many large scale chains in the childcare industry are franchise businesses. We have clients who we represent who provide sports and education for young children who are involved in franchising. We represent B2B businesses that are franchised, like logistics businesses, shipping businesses, and the like. So it really is, there's an enormous scale of franchising in the US and internationally. There's an enormous number of different types of franchises, not just limited to food, although, my rough estimate of both my client base and what I see in franchising is it's over 50% certainly in the food industry.
Oh, wow. And are we talking today a state, the US, global? What's the realm?
Well, and we practice in the United States, of course, and so franchising is an international business, and it's most prevalent in the U.S. But we also represent clients who are looking to expand their business overseas through franchising, as well as what I refer to sometimes as the inbound franchising. That is a franchise business outside of the U.S. that wants to build a franchise in the U.S. And I can explain legal requirements for all of that. But what I've learned in the years I practice this is that there are a wide variety of franchises all over the world. Britain is an example of a fairly mature market for franchising. Some markets are growing. The U.S. certainly has the biggest franchise business in the world, but there are certainly other countries that are actively involved in franchising, both domestically there as well as importing brands from other countries.
Okay, absolutely. Yeah. And you see American brands here in sometimes a different franchise model. Like there are regular Starbucks in the UK where I live, just for those listeners in London, even though I'm obviously not British. And then there are franchise Starbucks, and they do have slightly different models, or like they can only use the app for certain things like that. So you do experience, it is a slightly different experience, but you can have both in the country versus Subway, no matter where you are in the world, smells the same. And you can recognize the Subway with your eyes closed. But I mean Subway, the restaurant, and probably the Subway, the public transit. But
there is the desire or the intent of franchising is to regularize the way people experience the business. So most often, almost always, there's a trademark or trademarks that are associated with the brand. Oftentimes there is what is referred to as trade dress, or the design of something. Every McDonald's looks the same. There's a golden arch someplace. And all other businesses that I know in franchising have design criteria for their franchisees to open, and they should look the same so that the user experience, the consumer experience, is the same, whether it's in London, in Prague, or in the US someplace. It should all be the same, and it often is. That's what the intent is anyway.
Fair enough. And intent is sometimes exhibited or sometimes not. But when you think of the different industries you've just mentioned, including food, there's a lot of regulations surrounding or childcare or anything with hygiene, anything. There's a lot of unions around a lot of the home care, things like that. There's a lot of regulations. So can you tell us more about what the regulations and legal requirements there are to both be a franchisor, I believe it's called, or a franchisee? And just to be clear, a franchisor is someone that owns or runs the franchises, and if it owns the mothership per se, and then the franchisee is the individual restaurants, etc., operators. Okay.
Right. So let's start with definitions. As you said, franchisors are the owner of the brand. They are the owner of the trademark. They are the party that licenses the right to a franchisee to operate a business using that trademark, using the system that the franchisor has established, and generally paying a fee for the privilege of doing that. And the party that pays the fee, that uses the trademark and system established by the franchisor, is called a franchisee. In the U.S., which is most of what I'll talk about, in the U.S., franchising is regulated by the Federal Trade Commission, FTC, as well as by a patchwork of laws and regulations at a state level. And not all states regulate franchising. There are 13 states that regulate it in a way that I'll describe in a moment, and there are other states that regulate what are called relationship laws that pertain to the relationship between the franchisor and the franchisee after the franchise agreement is signed. So to start with, a franchisor that wants to sell franchises to a franchisee, in most cases, subject to some exemptions, is required to provide to a franchisee prospect, someone thinking about buying a franchise disclosure document. And that document is referred to as an FDD, or franchise disclosure document. That's the initials for it. An FDD contains investor information. What does it cost to buy this franchise? What's the history of the franchisor? How long have they been doing it? How many franchises do they have? What are the fees going to be? What's the background of the people who are running the franchise business, including whether or not they've been sued or in bankruptcy or have had criminal liability for anything. There are lists of trademarks and patents that the franchisor may license to the franchisee, and a whole host of other information about the deal. The FDD also contains an agreement that the franchisees are required to sign called a franchise agreement, not surprisingly. And it also includes a host of other documents that are required by the franchisee, required by the franchisor for the franchisee to sign. That package of documents is called an FDD. The Federal Trade Commission mandates that franchisees be provided with the FDD 2 weeks before they can sign a franchise agreement. So it gives them time to look at the document, get an advisor to look at the document, and really kind of a cooling off period in a way. Certain states regulate this. As I said, I practice in New York. New York has laws that require the filing of the FDD with the regulatory bodies in New York, who review it and approve it. And they're not approving the deal, they're approving the contents of the franchise disclosure document to make sure they're compliant with New York regulations, which are similar to the Federal Trade Commission regulations with minor variations. There are 13 states that require this registration. Other examples are California, Washington State, Maryland, Illinois, North and South Dakota, Hawaii. I can give you the rest of them, but I don't want to put people to sleep. There are 13 states. There are other states that mandate some sort of compliance that's similar to this if the franchisor doesn't operate with a registered trademark, a federally registered trademark. Again, those are a different set of rules, and it's not necessary for this program, but there are rules that you have to follow in a wide variety of states. And then once the agreement is signed, some states regulate the relationship. That is, how much time you have to give a franchisee before you cancel an agreement. The ongoing requirements of the franchisor for allowing the franchisee to renew a franchise agreement when it's about to expire, that kind of thing. That's the kind of the legal regime here in the U.S. And so the creation of this document is what lawyers who do what I do spend their time on. We create the franchise disclosure document. We make sure it's compliant. It has to be updated every year. There have to be financial statements. There's a whole litany of rules associated with this. And they're intended to protect the investors or franchisees. You made an interesting point about the regulations around some kinds of businesses, right? Childcare. We have clients who are in the health and beauty, massage places, estheticians and the like. Those businesses are regulated. Childcare businesses are regulated. Restaurants are regulated by departments of health. And those regulations, and schools are regulated in New York by the Department of Education. I mean, there's a whole bunch of different regulations around a lot of industries. And they're different at a state and local level. And the franchisor, like New York City has a different set of regulations than New York State does, more exacting in most instances. And so the rules around the operation of the business that you're obtaining the right to operate are different than the rules around franchising and legally selling franchises. So franchisees are really tasked with the responsibility of complying with those laws. Franchisors, for a wide variety of reasons, don't tell their franchisees what the Department of Health regulations are about opening a restaurant in New York. They only say that you have to comply with local regulations, rules, and laws that pertaining to your business. So if you're in the childcare business, and everyone who works in a childcare center in most states needs to be licensed, it's not up to the franchisor to get them licensed or make sure they're complying with local laws about licensing. It's up to the franchisee. Um, Other than the method and manner in which the franchisee operates the local business as a franchisee, there's no regulation around who can and who cannot be a franchisee. I mean, this is a private contract between a franchisor and a franchisee. Franchisors typically have their own criteria for whether or not they're going to approve a franchise or not, a franchisee or not. And that has to do with financial acumen and work experience. Restaurants, for example, often want to have franchisees who are familiar with the restaurant business. Childcare want to have people who are involved in education and know something about it. So there's a whole host of rules that the franchisor may make about who it's going to accept as a franchisee or award a franchise to. One thing I want to mention about this, because a lot of what people think about, many people think about, and the way this business was years ago, was that franchisees were smaller operators. In our experiences, we represent both franchisors and franchisees, as I mentioned before. So our franchise or clients range from startup franchisors, those that are just getting in the business of franchising their concept, to franchisors with hundreds of franchisees all over the country and internationally. On the other side of the coin, the franchisee, we represent mom and pop startup franchisees opening their first restaurant, their first painting location, their first childcare center. We also represent clients with 20, 30, 40 franchises, 40 restaurants, maybe more than one concept. It may be a guy or a business that owns 20 Dunkin' Donuts and 20 hamburger joints. The business has grown, the sophistication and investment made by franchisees has grown. And we're seeing, and we have seen for a number of years, larger networks of franchises owned by individuals or companies, in some cases hundreds.
So I understand the reasoning, especially with the big brand name, established brand, why someone would want to be a franchisee. There's slightly less risk. There's automatic marketing in having those golden arches wherever in the world it may be. But why would a company choose to be a franchise or versus to just be a chain? Is there a legal emphasis, there's less risk in being a franchisor than a chain, or what is the logic behind that?
Well, I mean, you're talking about why would an investor, someone who wants to run a restaurant, buy into a franchise system as opposed to run their own restaurant?
No, the opposite, because I think I understand the idea that you would buy, why a franchisee would exist, because there's a lot of benefits, including name brand recognition. There's an established brand. People expect certain food. There's an established customer base,
right,
potentially. But on the other side, why would somebody want to be a franchisor instead of owning a chain of restaurants per se, or gyms or whatever it is?
Well, I mean, there's a lot of reasons for it. Yesterday I spoke to a client who has 5 restaurants in the Midwest. They want to grow through franchising. They don't want to operate restaurants in California. They have a staff of how large do they want to get? Do they want to open restaurants in 10 or 15 different states? Do they want to spend the money investing in 20 restaurants? Let's say it costs $1 million every time you open a restaurant. Do they want to spend $1 million 20 times in 20 places to open a restaurant, or do they want to get investors to invest that money and get a percentage of the revenue, which may not be as much profit as they'd make from being an operator on their own, but it certainly avoids or reduces risk for the franchisor and lets them operate and grow their brand that way. That's one benefit. So it's using other people's money, essentially, to invest with hopefully a good investment, and it's avoiding the necessity of having staff and managers and personnel go to a state 2,000 miles away to run a restaurant. Certainly there are large chains that operate stores and businesses all over the country that aren't franchised, but in the restaurant space, it tends to be a fairly common event for restaurants to franchise to allow to allow other people to invest in the concept so that they can manage the business, create the menus and so on, that make it a benefit for a franchisee to open that business in a remote location ultimately.
Is there a reason legally or in complexity, which is more complex, I guess, from a legal perspective in your case, and a contract law perspective, et cetera, which method of business, which business model is more complex to manage themselves, or as you scale, you always need counsel anyway?
Yeah, I mean, I think you do. And we represent clients who have 20 similar businesses in 20 different locations. You know, for those clients, we're doing all the leasing work, we're doing all of the acquisition of property. If they're buying property, we're helping them set up their businesses locally and so on. So there's legal work to do for that. But being a franchisor is different than being a restaurateur. It's an entirely different business. So every time that we speak to a client about franchising an existing business, we explain to them, you're no longer a restaurant guy. You are now a franchisor. And you have different requirements. You have to train people. You have to comply with legal requirements. You have to update menus for other people. You have to manage how they operate to make sure they're complying with your rules. That's a separate business. Some people believe that is many people, a lot of people I run across, believe that it's a better business for them to do that than to manage far-flung restaurants in other states. The legal requirements are just different because franchising has a set of rules that I described before, and you know, opening a business anywhere has a set of rules that I described before also, in terms of Board of Health, for example, or schools. So, you know, I think people make a choice about businesses make a choice about whether or not the best alternative or best approach for their growth is to create a franchise business or to open up as a chain, as you refer to it.
Is chain not accurate as a term?
Chain is an accurate term. That's exactly the difference. I mean, as a matter of fact, you know, a chain is you know, I mean, franchises can be chains and chains can be franchises. It's just, but chain seems to typically describe businesses that are not franchised, and I think that's an accurate way to describe it.
Okay, and then putting an international hat on, as we all have an international audience at IR Global, I assume franchising is more common when you're going to other countries because of the complexity of being in charge and setting up an entity. If you are franchising, do you have to set up a legal entity in another country? How does it work in different countries? Are they regulating franchises in other countries? How's that work?
Well, yes, is the answer. And it depends. Those are my two answers for the day.
Very lawyer.
Yeah, I try. Franchising is regulated differently in different countries, so I can't begin to tell you. I don't really want to give examples here, but you know, some states, some countries regulate it the same way the U.S. does, or has a, you know, a different kind of set of rules, but it's regulated. Some don't. Canada, for example, you know, there are, you know, there are different rules in different provinces. Ontario is different than Manitoba. And so there are a whole set of rules in Ontario. They're like the U.S. rules, but there's no registration of the document there. There are some countries where it's simply a matter of making sure the contracts are created in a certain way, and a certain amount of disclosure is given to the investors. But when we go, I have a U.S. brand that wants to expand in Europe or Pacific Rim. Then what we do is we analyze or review the law in the place where they want to grow. We use local counsel to make sure that the regulations are being followed. If we find that there are a series of regulations, there's no necessity of setting up separate companies to say franchise in Britain, although we think people should set up a British-based franchise or unit so they can establish a tax base and other rules and regulations can be followed that are local. And then they just have to comply with those rules. I mean, there are ways that you set those up that are different than, say, a franchise or if I'm a franchisor in New York and I want to sell franchises in Illinois, then I can do that by following the Illinois law, and it's relatively straightforward because it's an hour flight from New York. But if I want to sell a franchise in Britain, I may sell all of England to someone or all of the UK to somebody as a right to be a sub-franchisor for me and be in charge.
So you can sublet franchise.
Like that, yes. So what you do is you create what's called a master franchise. And the master franchise sells sub-franchises locally. So they're charged with the responsibility of creating the brand initially in the UK. So they'll open their first shop in London, their first 5 shops in London. And then from there, they will start selling the brand to others outside of London or in other places in London. And that's kind of the experience that we have. You know, someone might get an experience might get rights from the franchisor to open 100 franchises, either on their own or through sub-franchising, through master franchise rights sub-franchising. And so that's sort of the way that works in order to allow the franchise system to be directly managed by someone locally. And not all brands work that way. I mean, brands with very, very large businesses, like a McDonald's or businesses like that, they know how to operate all over the world without having a local person on the ground supervising and making sure and selling rights to other franchisees. They do it directly. They may have large scale franchisees, 20, 30 or 100 units, but they're doing it somewhat differently than a smaller company that has found some interest in another country for their concept and who wants to allow people to open franchises in another country. They may sell to someone the right to sell franchises there. Now, that's what I refer to as outbound franchising. Mm-hmm. Inbound franchising, that is, say there's a brand in England that wants to come here, or a brand in Taiwan that wants to sell franchises in the US. Oftentimes they work with master franchises coming in. So they will sell the rights to and assign the right to a local person in the US, possibly on a statewide basis, possibly on a regional basis, say, New England, Southeast, wherever it might be, West Coast. They may allow one or more people to have master franchise rights locally so that they can sell franchises in the US. The opposite, the reverse trend, the other trend in franchising is to bring franchises from other locations into the US, what I call inbound franchising. And we have been involved and represent a number of franchisors and franchisees who have acquired franchises or sold franchises for overseas brands that have decided to come to the US. Let's say a Taiwanese company wants to do bubble tea in the US. I only say that because I'm doing a bubble tea franchise thing now. Or a restaurant chain or a hotel chain or anything. They want to bring the concept into the US. Some franchisors, overseas franchisors, bringing a business concept to the US, most, in fact, will use what's called the master franchise model, which what I discussed in doing outbound franchising is similar here. So a franchisor will sell the right to someone to sell franchises in the US. And oftentimes, the way that's done is by selling a particular region or state. So you might sell New York, you might sell New England, the Southeast, the West Coast, something like that. Sometimes they sell the entire United States to a master franchisor who is tasked with the responsibility and given the right to sell franchises on a local level to other operators. And they're generally tasked with the responsibility also of creating the first version of that. So the first version of the restaurant in, say, New York or Miami, that they can then use as a model for building the brand in this country. Recently, though, I spoke to a client. I really was glad to hear this because I think it's a better way of doing this. Often a better way of doing this is they want to come here and operate their first 5 restaurants. They've identified a certain market for what they think will be the right market for their business, and they want to test it here. and they want to tweak it a little bit. And so they're creating their own beachhead here by opening five restaurants in the US in a geographical area in the Southeast, so, which they think is good for their business, and see if it works. And if it works the way they think it will, they'll sell more of that state, more of that region, and grow from there, and then sell master franchise rights for other parts of the US. So there are a variety of ways of doing it. Most often I see master franchises being sold to US operators who then sub-franchise, but oftentimes I see, well, infrequently, less so, but recently more people are telling me that they want to do their own prototypes in the US.
When you're dealing with a master franchise model or even franchising in general, is there less or more, or it vary by contract state, everything, legal culpability if something goes wrong? For example, a food poisoning outbreak or E. coli outbreak in a restaurant. Touch wood for all of your clients, that doesn't happen, but obviously you're still taking on the risk from brand recognition and things. But is there less risk, more risk? Is this something you as the lawyer can help them negotiate into their contracts, or is it all really well regulated and straightforward for stuff like that?
Well, nothing's straightforward, and it depends. But to use your example of food poisoning, the franchisee is responsible for the operation of their restaurant. The franchisor is not. The franchisor has a set of rules. If the franchisee doesn't follow it, they're violating the franchise agreement. If someone becomes ill as a result of eating a hamburger in some franchise restaurant someplace, the franchisor is not really responsible for that. However, you can be sure that if the injured party hires a lawyer, that lawyer is going to sue the franchisor as well as the franchisee and everyone they can find, because that's what you're supposed to do as a lawyer. And there's a whole body of law on the question about whether or not the franchisor is liable for the actions of the franchisee. And it's complicated and it's different in different places, and there's sets of rules all over the place about how that is governed. But the way that you mitigate that risk associated with that as a franchisor is by mandating that your franchisee obtain insurance, a fairly significant amount of insurance, and that your franchisee also has the franchisor named as an additional insured. So the franchisor is covered under the franchisee's policy. And that's the way you mitigate the risk to the extent that you can. You're always going to be sued. So you really should have insurance on your own as a franchisor, but you also rely in large part on the franchisee's insurance. And then there are a couple of other issues associated with this, but the most prominent is the reputational risk associated with that kind of a problem. And food poisoning is not the only time that happens. There can be a CEO who says something they shouldn't have said, or arguably shouldn't have said, or something that goes wrong, or a crash by a truck that's being operated by a franchisee. Any number of things that are going to create some turmoil in the franchise system as a whole. Mm-hmm. And there's no way you can contract out of that. But there are emergencies, and there are companies that address issues like reputational risk associated with any business, and do so in the franchise world.
And in the opposite, and I just was going to Google, as I do often on these calls, and I found out that a certain pizzeria chain is a franchise model if the CEO of that chain is, I believe it was removed because of rampant sexual harassment and things, and the figurehead of that chain, no less. A franchise, then maybe this isn't the best example because people are going to buy cheap pizza no matter what the moral implications of it, but can a franchisee then sue the franchise because they've blasphemed the brand of that particular pizzeria or something like that? If something like that happens, does the franchisee also have rights in that situation, or if they've done something to the brand that's horrific?
That's a really complicated question too.
Good.
And it more than depends. I mean, it is certainly something that's happened. Lawsuits have been filed. Franchisees have tried to get out of franchise agreements because of issues like that. Not that specific example that I know of, but franchisees often organize into groups to sort of ask to mandate change so that if their franchise has a public relations disaster, let's say, somebody is, there may be efforts to change the model or change the governance of the company or whatever it is, just to address it. But, in general, franchise agreements don't cover issues like that.
And what about labor? We haven't touched on that, and we have very little time, so I only want to touch on it a bit, but specifically when talking about the US and specifically in restaurant world, like there are different, is that left to the state regulations, or do franchises have to follow? Can that be something that a franchisor puts in to their contracts with the franchisee, that they have to provide, say, healthcare or something, or is that completely left to the states then to regulate, or how does that work?
Another complicated question and answer, but there's a lot about that out there. Franchisors generally shy away from taking any control, even minimal control, over the way franchisees hire, fire, and treat their employees and pay their employees. The more involved they are, the more risk they have. Let's just say that. And it's really complicated, and it changes from month to month. What the law is, and it's state by state, and it's labor department issues and politics. Yeah, I mean, it's complicated. But I mean, the best advice that I can give a franchisor is to tell the franchisees that they have to comply with all laws, including labor laws, and operate their businesses in accordance with a set of rules that exist for any employer.
Fair enough, and consult their friendly lawyers, because it's going to be lawyers talking to lawyers in this situation a lot, right? Helping to clarify the communication legally. As with all things, we go on for days. There is so much information, and obviously there's a lot of complexity built into the many layers of government involved in the many different ways you can franchise or become a franchise. So I thank you so much, Michael. How can listeners get in touch with you when they obviously want to learn more about you, your legal services, or if they have any more questions? What's the best way to get in touch, Michael?
I'm sure the best way to communicate with me is through email. It's the easiest way. I always return and respond to emails soon after getting them. So my email address is me@ed-lawfirm.com. Our website is ed-lawfirm.com. There's a lot of information about our franchise practice and our practice in general there if you want to get more information. But contacting me via email is the best way to do it, and I'll respond promptly.
Very good. That's the opposite of me with email, but I definitely can vouch that your website, for someone that had no idea about this, is a very good learning resource as well. And thank you so much to our listeners. As always, these digital podcasts are meant to be educational resources from experienced lawyers, accountants, and financial advisors. These trusted advisors that have this extensive knowledge on topics you as professionals need to know more about. To learn more about IR Digital and its services, please visit irglobal.com. And if you found this episode useful, please consider sharing it, and don't forget to look in the feed for the other conversation with Michael. Thank you so much, and have a great day, y'all.